5 seconds to go. Start. It is also specifically stated in paragraph 9 that he has not fully cooperated with the investigation, as is apparent from the factual report dated 23rd November 2021. Stop. Para. On the other hand, respondent number 2 had sought to justify the order passed by the High Court. Stop. According to the learned counsel, the appellant is exploiting the respondent number 2 and his family members, the reasons given by the High Court while passing the order of anticipatory bail is based on legally admissible facts and the circumstances placed before the High Court. Stop. He also submitted that once the High Court has exercised its discretion, this court may not interfere with the same. Stop. It is also submitted that other FIRs registered against the appellant and her relatives is by third persons / strangers who are victims of extortion by the appellant and her relatives. Stop. They have nothing to do with the respondent number 2. Stop. Para. Law on the applicability or grant of anticipatory bail under section 438 CRPC may be briefly summarized as under: para. In Shri Gurbaks and others versus State of Punjab, a constitution bench of this court, Chief Justice speaking for the court dealt with in detail on the considerations for grant of anticipatory bail. Stop. Para. This court, relying upon the constitution bench judgment in Shri Gurbaks, laid down in paragraph 112 of the report the following factors and parameters to be considered while dealing with in application for anticipatory bail: para. The nature and gravity of the accusation and the exact role of the accused must be properly comprehended before arrest is made. Stop. Para. The antecedents of the applicant, including the fact as to whether the accused has previously undergone imprisonment on conviction by a court in respect of any cognizable offence. Stop. Para. The possibility of the applicant to flee from justice. Stop. Para. The possibility of the accused's likelihood to repeat similar or other offences. Stop. Para. Where the accusations have been made only with the object of injuring or humiliating the applicant by arresting him or her. Stop. Para. Impact of grant of anticipatory bail, particularly in cases of large magnitude affecting a very large number of people. Stop. Para. The courts must evaluate the entire available material against the accused very carefully. Stop. The court must also clearly comprehend the exact role of the accused in the case. Stop. The cases in which the accused is implicated with the help of sections 34 and 149 of the Penal Code, 1860, the court should consider with even greater care and caution, because over implication in the cases is a matter of common knowledge and concern. Stop. Para. While considering the prayer for grant of anticipatory bail, a balance has to be struck between two factors, namely, no prejudice should be caused to the free, fair and full investigation, and there should be prevention of harassment, humiliation and unjustified detention of the accused. Stop. Para. The court to consider reasonable apprehension of tampering of the witnesses or apprehension of threat to the complainant. Stop.